Perfect. Well, I want to welcome everybody. I am so excited for this evening. I'm particularly excited for our topic. And then, of course, I'm not that secretly really excited for our guest this evening, who has become a really wonderful friend to the civic and constitutional education space. So this evening, we are here once again with Montpelier and the Center for Civic Education. My name is Christopher Riano. I'm the president of the Center for Civic Education. And joining me today from Montpelier is Emily Voss, who helps head up all of their constitutional education work. And even more exciting today, I'm going to be very brief. I have the opportunity to introduce somebody who is really a leader and scholar in the field of the topics we're talking about this evening, but even more importantly, somebody very dedicated to the space. Today, our special guest and lecturer is Judge Jeremy Fogel. Judge Fogel has had the privilege of serving both as a state court judge in California, as well as a federal court judge on the Northern District of California. He went to school at Stanford and received his Juris Doctor later from Harvard Law School. He has a number of incredible achievements. I will not go through all of them. One of the things, though, that I think everybody here should know is that from 2011 to 2018, Judge Fogel was the director of the Federal Judicial Center. So essentially, Judge Fogel was the teacher for all of the federal judges that go through the Federal Judicial Center. So he is in so many ways one of the most well-known federal judges in the entire country. He now has the privilege of being the inaugural executive director of the Berkeley Judicial Institute, which fosters work between the judiciary and ensuring that the judiciary is well understood and respected. And with that, I want to turn things right over to Judge Fogel to get us kicked off. And Judge, thank you so much for being with us this evening.
Well, thank you very much, Christopher. I'm delighted to be here. It's an honor to be part of this great program you have set up. We were talking earlier, and I shared with Emily Voss that my admiration for James Madison. It was late in coming. It was I was on my way to Monticello to see Jefferson's home, and on the way we went by a turnoff for Montpelier and said, well, let's go there as long as we're here. And it began a whole fascination with Madison and the incredibly significant work that Madison did in building the institutions of our Constitution and our country. So it's particularly meaningful to me to be presenting as part of a Montpelier program. It's also very meaningful to me to be talking about the 14th Amendment. And before I get into the substance of what I want to talk about and hope that we'll get to have some Q&A about later, I'd like to say why the 14th Amendment is a very personal matter to me. So all four of my grandparents were immigrants. They were all naturalized citizens. So I grew up with that as part of my family heritage and some understanding of what it meant for people to come from places where things had been very tough for them, where they left not because they wanted to, but because they had to. And they came to the United States as a place of refuge from the persecution that they were facing in the place that they came from. And one of the parts of the 14th Amendment, which we'll talk about in a little bit, is the rights of naturalized citizens and who is a naturalized citizen. But the experience of my own family of having four naturalized citizens among my grandparents became particularly salient when later I became a federal judge in 1998. And one of the things that I got to do as a federal judge was preside over citizenship ceremonies. The naturalization of people who had gone through the process of becoming United States citizens and administering the oath to them and saying a few words at their naturalization ceremonies. It was so profoundly meaningful to me because of my personal history, but also because it was obvious to me how much it meant to the people to whom I was administering the oath. You know, if you're born in the United States, you're a natural born citizen. You don't have to do anything to become a citizen. You simply are one. But if you are a naturalized citizen, there's a very arduous process you have to go through. So imagine that you're coming from a place where English is not your native language, and you have to first of all get here legally, which is not always easy, and secondly, you have to obtain legal residence status, and thirdly, you have to learn the language well enough to undergo a fairly rigorous examination about what the principles and particulars of our system of government are. Then you have to pass the test. And so when you get to and you have to be here for 5 years at a minimum before you can become a citizen, even if you do all of that. So, for the people who were the participants in these citizenship ceremonies, you could see how much it meant to them. You could see how hard they worked. You could see that for them, it wasn't a matter of being born to, it was a matter of having worked for it. And people would bring their families, and when I say they bring their families, it wasn't just their spouse or their kids. They would bring their whole extended clan. And we used to do the ceremonies. I was in San Jose, California, and we did the ceremonies in the Civic Auditorium, which holds about 2,000 people. It was bursting to the seams with people who were there to watch their family members be sworn in as citizens. So it was a tremendously important ceremony. It was a very moving ceremony, and I got to do it a number of times, and it was one of the highlights of my time as a federal judge. And when you think about being a judge, actually people don't come to see judges because they're happy. They come to see judges because they're unhappy, because they have problems or grievances or issues with other people. One of the few things you get to do as a judge, that's just all good, is swearing in new citizens. So I just want to start with that high note, because I think it's a framework for what I'm going to talk about tonight. If you go back to the founding, and we always talk a lot about the founding and what the founders were doing. At the founding, to be a citizen, you essentially had to be white, you had to be male, and you had to own property. So, when you think about what the conceptions of citizenship were in 1789, we're talking about white male property owners. Then we went through a period of time between then and the Civil War when there were a lot of problems with that. When slavery became a tremendous bone of contention, and slavery was specifically and consciously countenanced at the founding. It was in the Constitution. It was acknowledged. And then we had a civil war over it. And after the Civil War ended, there were 3 amendments right after the Civil War that they're sometimes called the Second Founding. They were intended to be a restatement of what the fundamental principles of our republic and democracy are. In the 13th Amendment abolished slavery. The 14th Amendment, which is what we're going to talk about tonight, and the 15th Amendment was the voting rights. And it's interesting that even then, when you think about this as a historical process, remember back at the beginning, you're talking about white male property owners. There was a big debate at the time that the Reconstruction Amendments were adopted, the 13th, 14th, and 15th, as to whether it meant everybody or it just meant men. And there was a very significant and vigorous debate about that. And it ended up being resolved, and we'll talk about this when we look at the language, that there was a conscious decision to state the principles of the founding, of the second founding, as being colorblind, so that you would not discriminate on the basis of race, and that all persons were entitled to equal rights irrespective of their race. But actually there was a conscious decision not to call out women as part of that equality. So that was a point in time in the 1860s where that issue was presented, and that was the resolution of it. And of course, that came back to be a significant point later on, and we'll come to that. So that's what happened in the 1860s. Then there was a lot of pushback against that from the former Confederacy. And in 1876, there was a very closely contested election, and there was a political compromise made, or a political trade-off made, where in exchange for President Hayes winning the election, the federal troops were taken out of the South, and the Southern governments, the restoration, they called it, were able to basically undo what had been intended from the Reconstruction Amendments. There also was some very significant input from the courts, and even before 1876. One of the things we'll talk about in the 14th Amendment is the Privileges and Immunities Clause. It's one of the important parts of the 14th Amendment. And there were decisions made by the Supreme Court in the 1870s that greatly narrowed the scope of that to the point where discrimination against people by the states was essentially countless, notwithstanding the language of the 14th Amendment. So then we went through a period from roughly 1876 until the 1960s, so a long time, almost 100 years, which could be characterized as the Jim Crow era, where, notwithstanding the 14th Amendment, states were allowed to override some of the things that the Reconstruction Amendments were intended to achieve. And the most notable example of that, the one that's cited all the time, is the school segregation case, Plessy versus Ferguson, which said separate but equal was okay under the Constitution. I think the people who wrote the 14th Amendment would have been very surprised to see that, but you're a generation later, and that's what the court said. And so it took close to 100 years for that to begin to unravel. And now we're in a modern era where the 14th Amendment has been seen increasingly as a vehicle for achieving various kinds of equality and equal treatment and equal dignity for all people. There's a debate, and we'll talk about that when we look at the language, as to whether it's sufficient to guarantee equal rights for women. There is legislation certainly that addresses that, but the question of whether the 14th Amendment addresses that is an open question. There is a lot of discussion of the 14th Amendment in cases involving same-sex marriage. The Obergefell case, which stated that same-sex marriage was protected by the Constitution and by the 14th Amendment, was kind of the most recent and the strongest application of that notion. But you think about that in relation to what was going on in the 1860s, it's a pretty huge progression over that period of time. So that's kind of the arc. And I want to say just a couple more things before looking at the amendment in more detail. And one is that the right of citizenship, once you have it, doesn't really carry a lot of specific affirmative responsibilities with it. And that's not true of every modern democracy. There are countries where voting is mandatory. There are countries where citizens have other affirmative responsibilities. We really don't. You can lose your right of citizenship by committing a felony or other kinds of conduct that causes you to lose your rights. But in general, being a citizen does not require you to do anything in particular. And that's just something that we need to think about as we go through this, because one of the points of civics education is to talk about the meaning of citizenship, the responsibilities of citizenship, what you do with the rights of citizenship. But there's nothing in the Constitution itself that really gives us much guidance there. So what I'd like to do now for a little bit is kind of walk through the 14th Amendment. Some of the amendments are pretty short. They're pretty clear as to what they mean. This one is neither short nor clear. It has lots of ambiguity in it, and we are 150 plus years past its adoption, and we're still arguing about a lot of its core provisions. All right, let's see here if I can get this to, there we go. All right, so this is section 1. It's a little wordy, but it basically says that if you're born or naturalized in the United States, that you're a citizen, and you can't be deprived of your privileges and immunities without due process of law, or be deprived of the equal protection of laws. But what I'd like to do is break down some of the language here, and I think this is kind of what lawyers do and what judges do. It's what we're trained to do. But these breakdowns actually are quite significant when you think about what they mean for people in real life. So the first phrase I've highlighted is subject to the jurisdiction thereof. Now, why have I done that? Well, what this meant, I think, at the time of the adoption of the 14th Amendment was that if you were the child of a diplomat, say you were the ambassador to the United States from Germany, and you're born in the United States, that would not make you a citizen, because your parents are not subject to the jurisdiction of the United States. They're ambassadors. They are subject to the jurisdiction of the country that sent them. So I think that's sort of the narrowest, and it's always been the historically accepted interpretation of this language. This, however, has come up recently in the debate about birthright citizenship. There's a school of thought that people who are in the United States illegally, in other words, people who come here without documents and do not have a legal right to be here, and then have children who are born here, that those children are not covered by the 14th Amendment because their parents are not subject to the jurisdiction of the United States. They weren't here legally. My personal view is that that's a pretty difficult argument to prevail on, because I think the history of the amendment is much narrower. But this language has been cited by people who believe that birthright citizenship is not provided by the 14th Amendment. So this is one of the areas that still, even now, people are arguing about. What does it mean that people who are born in the United States become citizens of the United States? And so this is a political controversy, and this is the language that's the focus of the controversy. Another part of Section 1 that has been a subject of a lot of discussion, not so much recently, but it's actually coming back for reasons I'll try to explain, is the Privileges and Immunities Clause. So at the time that this was adopted, some people thought it meant that the states couldn't discriminate against anyone, that it simply meant that if you were a citizen of the United States, you were entitled to the same rights regardless of where you went. And the Supreme Court in the Slaughterhouse Cases in the 1870s said otherwise. They said that, you're just talking about the privileges and immunities of citizens of the United States. And then they defined what those were in a very specific way. They distinguished the privileges and immunities of citizens of the United States from the privileges and immunities of citizens of the states. So you would have the right as a citizen of the United States to travel on an interstate highway or river. You'd have the right to various kinds of customs protection and things like that. But they were a very limited set of rights that you had because you were a citizen of the United States, as opposed to being a citizen of a particular state. So if you look at those cases, what they did was they narrowed the privileges and immunities of citizens of the United States to be a pretty small and largely inconsequential set of rights. And that's been the law for 140 years, 150 years. There is some indication that the Supreme Court, and it's interesting, it's not the liberals, it's the conservatives, may be bringing the privileges and immunities clause back to a clearer version of what it meant, primarily around property rights. But in any event, this is one where you can really see what the power of the courts is to interpret language. I think it's fair to say that Congress meant this to be broad. The courts in the Slaughterhouse Cases decided that it was narrow. Another one that is of consequences: what does it mean that someone is a person? This obviously became a big deal with regard to people who had been slaves and no longer were slaves. There has been a question as to whether it applies to women. Of course, women are people, but the question was whether, given the other language in the 14th Amendment, this person language is sufficient to cover people of both genders, and in fact, all gender identities. It's unclear whether that's what the 14th Amendment means. Due process. So, the narrow version of this is you can't deprive someone of life, liberty, and property without having a hearing before a tribunal and a right to be heard and a right to make arguments. The due process clause has been interpreted more broadly than that. And in fact, there's a whole body of law called substantive due process, which has nothing to do with the procedures that apply in a tribunal and have to do with whether the government can deprive people of certain rights of life, liberty, and property without due consideration of the importance of those rights. And in fact, the Obergefell case, which I talked about earlier, the same-sex marriage case, is grounded in this language, that there's a right of dignity, a right to life that cannot be taken away by state prohibitions against same-sex marriage. So it's a way that this particular language has evolved. And then this one is really fascinating to me as a judge. So this is the Equal Protection Clause, and it comes up all the time, and it comes up in discrimination cases primarily. There are laws in all of the states and in the federal statutes that talk about discrimination. The question is, what is this 14th Amendment talking about when it talks about equal protection of the laws? And this is not unambiguous. You could argue that it means you can't have laws that discriminate, that the laws have to protect everybody equally. And this is one of the arguments that was made about why you don't need the Equal Rights Amendment, because you have the Equal Protection Clause. But a narrower reading of this simply means that you can't apply the laws unequally, that whatever the laws are, they have to be applied equally to all of the people that they affect. And that's a much narrower construction when you think about it. So this is an area of continuing ambiguity in the 14th Amendment. So here's section 2. And this has to do with voting and apportionment. So we just had a very significant case that the Supreme Court was considering about the census. In fact, they had a couple of cases about the census, and the question was whether undocumented people could be counted or should be counted in figuring out how many people live in each state for purposes of the census rather. And again, this language, which seems pretty straightforward, became quite a bone of contention. So what is the whole number of persons in each state? You could argue, and I think personally the better view, and I think perhaps the view of most of the justices, was that if you count the people who were there, it doesn't say the number of citizens, it doesn't say the number of registered voters, it talks about the whole number of persons. And it goes back to the meaning of persons. But that's to point out that here's something that was adopted in the 1860s. It is still 150 years later, we're still arguing about it. So what does this language in section 2 mean? Now, I highlight the male and 21 years of age provisions only because they have since been changed. They've been changed by constitutional amendment. So the 19th Amendment eliminated the restriction of voting rights to men, and later there was an amendment to include people over the age of 18 rather than 21. So So you have this change, but at the time of the adoption of the 14th Amendment, it was talking about men over the age of 21. And then this is the amendment provides for the disenfranchisement of people who've been convicted of serious crimes. It was originally intended to deal with people who had been participants in the rebellion, in the Civil War, but it also provides sanction for depriving people of voting rights if they've been convicted of other crimes. And that, of course, has been again, a very contemporary issue. How far can you go with that? How far should you go with that? So Section 3, I mean, we didn't really hear much about Section 3 for a long time. This has to do with basically denying people seats in Congress if they engage in insurrection. This was aimed at people from the Confederacy who had not taken responsibility for the rebellion and then were elected to the House. This was a way that the House and the Senate could exclude them. But we've had some discussion very recently based on the January 6th incident at the Capitol, where people are saying, well, maybe this should apply to some of the people who were involved in that, who are now serving in Congress. Not sure this is actually going to come to pass, but it's been a long time since Section 3 became a matter of contemporary interest, but this language is actually in play right now. I have to say, Section 4 is the one part of the 14th Amendment that I'm not going to talk about. This has to do with compensation for the loss of slaves who were considered property. And I don't think that's come into play anytime in the last 100 years or so. But here's Section 5. And this has to do with the right of Congress to enforce the provisions of the 14th Amendment by appropriate legislation. And this always is a topic of discussion. So how far can Congress go in enacting social legislation? What type of license is it given by the 14th Amendment? And that's also been a matter of some debate. And so judges will see this on their plate in constitutional litigation. Is Congress acting in excess of its constitutional authority? And Section 5 states this very broad goal of creating equality and creating inclusion and so forth. But there's been debate for a very long time as to how far Congress can go in carrying that out. I just want to go back before I turn to your questions in saying that here's something that was meant to be, I think at the time that it was created, it was meant to be a reformulation of what being an American is. So you think back to 1789 and you're talking about white male property owners, you're talking about a society in which slavery is a assumed part of the economy and in which women have no political power or influence. And then you look at this amendment as a step to kind of restate the contract, to restate what it means to be an American. And what I've tried to do in the last few minutes is just identify how some of the battles that we're having right now in trying to figure out who we are and what our values are, that this amendment provides some guidance, but it also has a lot of ambiguity in it. And I think that's a good jumping off point for a conversation about the 14th Amendment.
Thank you, Judge. So you might want to leave your slides available just because some folks have had questions pertaining to Section 1.
All right, I'll come right back then, just a sec.
Well, while you're bringing that up, I'll bring up the first question. So from Sharon, I have a student who asked if she could ever be president. She was not born in the United States, but her parents were. They're not in military service. So how would we respond?
All right, here we go. Let me just get this back up. All right, so if you are not born in the United States and your parents were not either.
The parents in this case are American.
American citizens.
Yes. So perhaps expatriates, the question asker did not specify.
All right, so this assumes both parents are American citizens, but the person was physically born outside the United States. Yeah, I think the answer to that question is yes, but that has been debated. It came up with John McCain, who was not born in the continental United States. He was born in an American territory. He was born in the Canal Zone. It came up with Ted Cruz, who was born in Canada of American parents. It came up with, you'd have to go back a ways, but there was a guy named George Romney, who was Mitt Romney's father, who was born in Mexico in a Mormon colony, but his parents were US citizens. So there's never been a real definitive, there's not a court decision that I'm aware of. I think the weight of opinion is that if both of your parents are citizens, it doesn't matter where you were born. But you can be sure that if you ran for president, that somebody would raise it.
All right, Sharon, you can bring that to your student next time you have class. All right, Leroy asks, is a corporation a person?
Okay, well, I'm going to try to answer that question without taking sides. So this was the question in the Citizens United case. I mean, this was the thing that the Supreme Court decided that, for, at least for purposes of First Amendment rights, that corporations were people, and that led to the decision in Citizens United. When we had the program, the FJC. When I say we, my former agency, we had a program at the National Constitution Center in Philadelphia, probably 7-8 years ago, and it was a program where we were talking about Madison's legacy, and we talked about this, and we actually had a debate between a couple of federal judges who were on different sides of the issue. And one of them said, you know, at the time of the founding, and even at the time of the 14th Amendment, that corporations were not what we think of today. I mean, there was no General Electric, you know, there was no Apple, you know, it was, corporations were pretty small, and they were really more for the purpose of just dealing with taxes and things like that. And they tended to be relatively modest entities. So the modern corporation was unknown to people at the time that these texts were adopted. And so that particular judge made the argument that there's no way that under the founding documents, either the original Constitution or the 14th Amendment, that corporations would have been considered people. The other judge said, well, you know, it doesn't say that they're not, and there were corporations then, and so it's fine to consider them people. You know, and I'll betray my bias. I mean, I think that's a mistake. I mean, I don't think that's what the framers of the Constitution or the 14th Amendment had in mind.
Thank you. All right. And then another question, isn't Section 1 in direct conflict with the Second Amendment, specifically in instances where states regulate open carry or concealed carry?
Well, that's a really, really interesting question. So the 14th Amendment talks about equal protection of the laws. It talks about not denying privileges and immunities to people. So it's been understood that you can't take away the states can't take away people's constitutional rights. I mean, there's a whole other track you can get there through, you know, because remember that the Constitution and the rights in the Bill of Rights apply to the federal government. They don't say anything about the states. I I mean, they talk about, Congress shall make no law, Congress shall not do this, Congress shall not do that. So there's this whole question as to which rights in the Constitution are binding on the states. Can a state government abridge rights that the Congress cannot abridge? And you'd think it's either all or nothing, but actually it isn't. I mean, there's been inconsistent jurisprudence on that. I mean, it's pretty clear that the right of free speech is incorporated. More recently, the Eighth Amendment, the cruel and unusual punishment's been incorporated. The right to counsel, the right to a trial, all of that's been incorporated. But the Second Amendment, I mean, that's we could easily do a program just on the Second Amendment, but the current jurisprudence on the Second Amendment is very broad. I mean, it's an individual right that Congress certainly cannot abridge, and the way the court is interpreting it, states can't abridge it either. So I would think that if you include that right, or that set of rights, as part of the privileges and immunities of citizens of the United States, that the states cannot abridge it. That is an argument that still needs to be joined. I mean, in fact, it is. I mean, there's gun cases in the Supreme Court all the time. And in fact, they're considering taking up another really significant one. And the question is, what can states and municipalities do to restrict the right to bear arms? What kinds of reasonable restrictions can they impose? But I think the question presumes that if this is a very broad right under the Second Amendment, that Section 1 seems to suggest that you can't abridge that privilege and immunity.
Judge, I want to jump in because I'm so curious about something that you've just mentioned. And I know questions are popping in, but you've said something that's really keyed in my mind that I'm fascinated to get your opinion on. We can look at Section 1 here, and Section 1 talks about the privileges and immunities of citizens of the United States. Then goes on to say, nor shall any state deprive any person of life, liberty, or property. One clause uses citizen and has basically become a nullity in so many ways, except as you discussed. One clause uses person, and we pack a lot of things into that clause. I'm just curious, Judge, what do you make of that? Why do you think maybe that's the way that this is sorted out over the years?
Well, I think, I guess I would qualify as a legal realist. I think decisions are made in the context of the times in which they are made. It's the only way you can understand how you could have Plessy versus Ferguson and Brown versus Board of Education, both decided by the Supreme Court. If you are more of a formalist, you would just say, well, Plessy is binding precedent, so Brown was wrongly decided, right? But you have a context in which courts are making decisions. So the privileges and immunities clause, and I think the Slaughterhouse cases are one of those parts. I mean, I could rant about this for a while, actually, about how little we understand about Reconstruction. That it was one of the most significant periods in our history, was really significant. And what happened kind of in the effort to undo the effects of slavery, and then how that got pushed back on. It is a fascinating story. And I think it's a story that has largely been badly told. I mean, there was a period of time when Reconstruction, certainly when I was growing up, Reconstruction was this terrible time, and there were these scalawags and carpetbaggers coming from the North and exploiting the people in the South. Well, there's no question that there were some people who did that, but basically the period of Reconstruction was an attempt to empower people who had been slaves, give them the right to vote, give them the right to own property, give them other civil rights, hold jobs. And what happened was that was very antithetical to what people in the former Confederacy wanted, for a lot of reasons. That just was not something that they were good with. And so when they had the opportunity, they pushed back very, very hard. And one of the key points in that saga was the Slaughterhouse Cases and the interpretation of the Privileges and Immunities Clause. So, you think about the question we started with gun rights. So, gun rights is a good one because it's not a liberal idea, it's more of a conservative idea. And so it's like, so doesn't the Privileges and Immunities Clause mean that if I've got a right to open carry, I got a right to open carry in all the states, and you can't take that privilege and immunity away? Well, what the Slaughterhouse Cases did was they said, no, that's actually not what this means, that the privileges and immunities of citizens of the United States, and this goes to your question, Christopher, not of persons, but of citizens of the United States. So it's actually a very small and kind of not meaningless, but a relatively inconsequential set of rights. I can navigate from Pennsylvania to Ohio on the Ohio River, and neither state can stop me from doing it. Because I have that privilege as a citizen of the United States. But that's the kind of thing that Slaughterhouse said was protected. And they did not say, and they said, in fact, this clause does not protect all of the other rights that people have or had, to vote, to own land, to be free of discrimination based on race. I mean, none of that is included in this privileges and immunities phrase. And that is the Slaughterhouse Cases. And that was a case which arose in the context of this debate over Reconstruction. So you sort of have to sort of think about the time in which it happened. And the person language is intentional, right? So it's just saying that nobody, doesn't matter whether they're a citizen of the United States or not, nobody can be deprived of life, liberty, property without due process of law, or denied the equal protection of the laws. And so the pushback there had to do with, well, so what is due process? What is equal protection? And that's why, those phrases became bones of contention as well. What does that mean? And so all of these fights occurred in the context of social turmoil that you had at the end of the Civil War. You had the radical Republicans who wanted to move from slavery to at least legal equality of the races. I mean, a lot of them did not want social equality. They weren't comfortable with that, but they wanted legal equality of the races. And then people in the former Confederacy who didn't want any of that. And what what we've learned in studying this, and why I think it's such an important period to study, was that the most important right, as it turned out, I mean, the right to vote was very important, and the right to not be lynched or killed, obviously, was very important. But the most important right that Reconstruction attempted to give to the former slaves was the right to own property. And that was the right that came under the sharpest attack, and that was the right that was not protected in the Reconstruction, in the post-Reconstruction period. So we're still living with that. I mean, we could have a session on structural inequality, but one of the foundations of structural inequality was the deprivation of property rights of the former slaves. So I mean, this is just so loaded with meaning. This part of the 14th Amendment.
Judge, I have, there are two questions of kind of a historic or contextual nature that I'm hoping that you can address for us. The first one actually has to go back to the Constitutional Convention. So you mentioned extremely briefly at the very beginning of the presentation that there isn't language in the Constitution that addresses citizen who is a citizen who isn't a citizen until we get to the 14th. Mm-hmm. So Sean has asked, was there a common understanding among the framers of the Constitution as to who was actually a citizen and what benefits that citizen had, such as voting? Or was there some sort of backroom discussion that we don't know about?
Well, no, I think it was a little of both, to tell you the truth. I mean, they were all naturalized, right? I mean, there was no United States. I'm trying to remember who the first president was who was actually born in the United States. I think it might have been Van Buren. It was a fair way downstream. I mean, the first 10 or so presidents, none of them had been citizens of the United States when they were elected. And I think there was also just the states had laws that voters were men, they were male, they were pretty much, I don't think they needed to say that they were white because they were all white, but they were property owners. So I think it was, my recollection is, there's nothing in the federal constitution, but it was left to the states. And then I think at some point, you started having people who were native born, but I think that they didn't talk about it because there was nothing, they really couldn't talk about it, right? Because there wasn't anybody who would have qualified then.
Okay, and then the second question of the sort of historical nature is a point of clarification. So you've referenced that the Bill of Rights only applies to the federal government, and it isn't until we get to the Reconstruction Amendments that now the Bill of Rights starts to be applied to the states. So could you please explain that a little bit further?
Yeah, I mean, so I think it's sort of implicit in this privileges and immunities idea, but it's independent of it. So there started to be a series. The Civil War kind of changed the conception of what the country was, I guess is the best way to put it. That before the Civil War, even though it wasn't the Articles of Confederation, it was still the paramount governments in people's lives were the state governments. The federal government was not much, right? I mean, it didn't have much to do. And there were presidents who had different notions of how to use federal authority, but the Jeffersonian view, that basically this, you've got states that are kind of doing their thing, and the federal government's there to keep you from getting, attacked by England or France or whoever might want to attack you. I mean, that is kind of what the governing conception was. Well, the Civil War, upended all of that. It was not possible. Lincoln had to base his entire government on the idea of restoring the Union and bringing the secessionist states back into the Union. So at the end of the Civil War, you had a concept of a country that was more of a single country than an aggregation of states. And so I think at that point, as you adopt these amendments, you're talking about, well, what can the states do? What can't the states do? And you're not in the pre-Civil War notion of what states can do. There's things that states can't do. You can't deprive people of, this language in the 14th about due process and life, liberty, and property, it's exactly the same language as in the Fifth Amendment. It's just lifted directly out of the Fifth Amendment. So certainly the first, the fifth, the sixth, the right to counsel and to trial and so forth. I think the more integral they were to the founding, then there's this idea the states can't violate them. There's some that never did get incorporated. It's not like all 10 of the Bill of Rights were incorporated, but some of them were not really very practically significant, like the one about quartering troops, the Third Amendment, which most people don't know, right? That's not a biggie. It took a while for the Seventh Amendment, the jury trial. It says, the Seventh Amendment says if there's more than $20 in controversy, you get a jury trial. Well, $20 is not even going to get you to taxi to the courthouse, so it's a little dated, but I think the key event to answer this question really is the Civil War. It changed the idea of what the United States means.
And Judge, as you know, and this is one of those things that us, constitutional nerds like you and I think about all the time. This incorporation is still happening, right? There was a case at the Supreme Court just 2 years ago, I think Timms versus Indiana was 2 or 3 years ago, where there was a question about the incorporation of the Eighth Amendment. And you could see, and it's one of those amazing transcripts, because you can see one of the lawyers trying to argue that that piece of the amendment should not be incorporated. And you can see every single justice kind of looking with one big eye saying, no, we incorporate things nowadays. That's what the 14th Amendment does. And it went right down the line of every justice saying, giving him the right to argue, but I think we're going to incorporate this part of the 8th Amendment. So this is still a process.
Yeah. No, that's right. And this amendment is meant to do that.
Mm-hmm.
The frustrating thing about it is, though, it doesn't just come out and say it, right? I mean, I'm a grammar nerd in addition to being a Constitution nerd, and I read this and say, what's that comma doing there? That's an incomplete sentence. That changes the syntax. I mean, that makes the whole thing incomprehensible. So, you go through this long 5-section amendment and try to figure out what it means. And actually, it's really hard if you parse it too closely. But I think it's very clear that what Congress was trying to do was it was trying to unify the Union. I think that's really what the overarching purpose of this amendment was to say this really is the second founding. We're trying to reframe what the United States is about. I don't think that's too grand a statement. I think that's really what they were trying to do.
So I want to pose maybe one more question, but I'm sure you have another portion of your presentation for us. So I'm hoping that this one will perhaps cue you up a little bit. Chris asks, since voting is a privilege of U.S. citizenship, what is the constitutionality of the current legislation underway in multiple states to constrain, monitor, however you want to characterize it, but more forcefully look at who is actually voting in their states?
Wow. Well, that's a complicated question. And by the way, I'm happy to take questions for as long as people want. I like this format a lot. So please feel free if there are more. But so voting is really covered by the 15th Amendment, which I wasn't planning to talk about tonight, but I think there are so many angles to this question about voting rights. And I'll just say that I'm not sure, I mean, other than in terms of racial discrimination and gender discrimination, which are specifically called out, I mean, by the 15th and the 19th Amendment specifically, that the Constitution doesn't really give you a lot of guidance. And the 14th Amendment talks about equality and equal protection. The Voting Rights Act, there were a couple of them, but I mean the most significant one was in 1965, was really meant to carry these ideas forward and say you can't have patterns of racial discrimination, and that's what they were looking at, was racial discrimination in voting. And at the time that it was adopted, it was very controversial. There was a lot of pushback. This was the same North-South split, but then it got passed, and we lived with it for a really long time. And then in the in the Shelby County case, the Supreme Court was asked to eliminate the pre-clearance requirement, which meant that in states that had a history or jurisdictions that had a history of racial discrimination in voting, that you could not change the rules without getting pre-clearance from the Department of Justice. I had a number of those cases. I mean, even though I sat in California, we had some counties in California that had history of discrimination against Latino citizens, and I was in a jurisdiction where we had a covered county, so I got these Section 5 cases, and it was really interesting because you were forced by the law to look at what the history was and say, okay, is this change in voting? And it could be just moving a precinct, it could be changing the voting hours, or it could be anything like that. Is that going to have a discriminatory effect? And you would look at that through the lens of the history of discrimination in that particular jurisdiction. And so in each of those cases, what happened was I never ended up having to rule against the counties, but it required them to kind of go back and look at their practices and find ways to make sure that they did not unintentionally or intentionally have a disparate impact on people. Shelby County did away with that. It did away with it on the theory that you don't need it anymore, that the preclearance requirement was something that grew out of the Jim Crow era and deliberate suppression of voting, and that's not what's happening anymore. So we don't need to have the preclearance requirement. It doesn't mean you can't go to court with a voting rights case, but you don't have the presumption that that you need to look more carefully at what's happening. So that's the law now, and these cases that are arising in places like Georgia and other places where there's a lot of legislative activity to change the rules for voting, I want to stress the people who are challenging those laws will get a hearing, but they're not starting with the presumption. They're not starting with the higher level of scrutiny because of the history of discrimination in that particular jurisdiction. That's the difference. And of course, that makes it a lot harder to prove. So this gets to a topic that I always like talking about, which is how people's life experience influences the way they look at the law. You know, this is a conversation about judges, and I was a judge for a long time, and I like judges, and I have a lot of respect for the judiciary. And whether or not I agree with the philosophy of a particular judge, I have a lot of respect for the culture of the judiciary. But there is a part of the way judges go about their business where you're saying, well, I'm going to figure out what the facts are. I'm going to have fact finding, and then I'm going to determine what the facts are. And then based on what I find the facts to be, I'm going to apply the law to those facts. And I think the great majority of judges do that. I think it's very unfair to judges to say that they just stick their finger in the wind and decide what the politics are. I think they really are very fact-driven. But, and it's a big but, so how do you find facts? What is a fact? You know, that what you think something is, I mean, none of us is like a perfect perceptor of what's going on out in the world. I mean, we are all human. We all have the limitations of our perspective, our life experience, our priors. I mean, it's just the nature of how people understand reality and make decisions. And I think what happens in voting cases, and not just in voting cases, but certainly in voting cases, is what you think, what Judge A thinks is a burden, Judge B may not see as a burden. Judge B may see it as a reasonable regulation or an attempt to address a demonstrated problem. And it doesn't mean that anybody's being intellectually dishonest. It doesn't mean that anybody is evil. It just means that people see the facts differently. And I think one of the things that we don't talk about enough with judges is the fact-finding role that judges have. I mean, in a jury trial, the jury is the fact finder, but judges do a lot of fact finding. And in these voting cases, judges do the lion's share of the fact finding because they're deciding whether to issue injunctions or not. And I think the social context in which the judge is making the decision and the judge's background and upbringing and orientation really do matter, and we don't talk about it. So what Shelby County changed was it changed the preset. It said that when you get a case like this, you start with the assumption that since this jurisdiction has a history of discrimination, you are going to look at the case through that lens. And without Shelby County, you don't do that anymore. So it's a much wider field, and I think there's a lot more room for individual variance. So very long answer, has nothing to do with the Constitution, but it does have to do with how judges deal with the problem of equal protection.
Well, I would say that most of us don't have the opportunity to actually have one-on-one conversations with federal judges. So this is more insight than most of us will ever get. So thank you for that. And I was also hoping, as a quick follow-up question, and I promise Stephen and Mike, we will get to your questions as well. But with regards to the last person who asked, this idea of rights and responsibilities of citizens.
Yeah.
This isn't in the Constitution. This is something that seems to have been built upon perhaps over time. So do you have a sense of where we get these ideas of the rights and responsibilities?
Yeah, boy, it was such a good question. So if you go back to before the founding, so who were the people who influenced Jefferson and Madison and who were the people whose visions of democracy and an enlightened governance, what did they think? And so you look at Locke, you look at Hume, you look at Rousseau, you look at people like that, and you can see in there, they're talking about responsible citizenship. You're talking about people being educated, being knowledgeable when they vote, being deliberative when they weigh in on things. It was not the circus. It wasn't just let's just round up the mob and let them vote. It was a very elitist notion, actually, of citizenship. It assumed education. It assumed property ownership, and a stake in things, and you really can see that in those early expositions of what a citizenship and a democracy would be like. I don't know how many of the people listening now are fans of George Will. I mean, he's kind of a throwback to that era. When I like reading his columns because he, in some ways, channels that. I don't think he adopts it 100%, but I mean, he's somebody who I think channels from time to time the idea of an informed and thoughtful citizen. Kind of weighing in on issues that concern the polity. Well, that's not how democracy works. I mean, there are people like that, but I mean, democracy also tends to be much less reflective than that. And people tend to be much more reactive and vote in what they perceive to be their self-interest, or they vote on the basis of their emotional responses, or they vote on the basis of their fears. And so I think it was kind of a very idealistic notion of what citizenship meant. But I think that's what the founders had in mind. And then I think there's always been this tension throughout the existence of the United States between sort of that very high-minded notion of citizenship and reality. And you really saw, I mean, to me, the tipping point was Andrew Jackson. I mean, where you finally had a president who really was the hero of the more of the reactive sort of emotional vision of democracy, as opposed to the more elitist and high-minded one. But so it's sort of in that context where you're sort of trying to figure out, well, where are we now? In some ways, we're still having the same debate. It's like, how much is it appropriate to expect of people, and who gets to decide what you expect, and what does it mean to be an educated citizen and an informed citizen, especially when you have such polarization, and you have so many different sources of information, and the sources of information are so radically disconnected from each other in some ways. So I don't know that there's an easy answer to that. I mean, I think one of the responsibilities of citizenship is to try to be informed, but where do you get your information from? And trying to prescribe that is a hard one. I think going back and looking at some of these early philosophers is not a bad thing to do, because you sort of see what the founders had in mind. They certainly were trying to create a republic that reflected some of those values.
Excellent. Okay, well, I promised Mike and Stephen we would get to their questions.
Mhm.
Okay, so with regards to the census, so somewhat backtracking a little bit, are persons who are present in the United States on non-immigrant visas, for example, student or tourist visas, are they counted and part of the calculation for apportionment, or would they be considered not subject to US jurisdiction, such as the diplomat example you gave earlier?
Yeah, well, that's, see, and I don't know the answer to that question. That is one of the issues in the census case. Um, the it talks about inhabitants. I mean, the word inhabitant is, I didn't highlight that, but that is one of the words in there. So what does it mean to be an inhabitant of a state? Right, and I don't think that's really defined anywhere. If you're on a H-1 visa or something for 3 years, are you an inhabitant of the state that you're in? These were things that the Supreme Court didn't decide in the census case because they ducked the case. Basically, they said that the Commerce Department had done such a poor job of deciding who they were going to count that they were just going to refuse to adopt it on administrative law grounds. And so it's unclear to me how this is all going to end up. I think the court probably will accept a reasonably reasoned and justified way of counting. I think that's my answer, but I don't think that really answers the question that the people asking the question are asking, which is, who should be counted. I don't think the Section 2 really tells us the whole number of persons in each state. That's very metaphysical. When are you there? And what does it mean to be there? I mean, the diplomat one has a legislative history. That's an easier one, and this one really doesn't.
Well, as long as we're on Section 2,
Yeah.
let me ask this other question that came in as well. So Section 2 lists except Indians not taxed. So does this imply that all who are taxed should be counted? Are some Indians the only citizens not taxed? And of course, I think this is different now than it was at the time of the writing.
Yeah, I was wondering about that actually when I was preparing, and I'm not sure this applies to anybody now.
To carry on the question, does this further indicate that an illegal alien now should not be counted since they are also not taxed?
Mm-hmm.
So was there a concept of an illegal alien at the time of the writing of this?
Yeah. Well, I mean, they're certainly not mentioned in here. Mm-hmm. But I mean, that's not a bad argument. In other words, if they're not taxed, but I wonder if that is an accurate premise. I mean, I think there are undocumented people who get W-2s. I mean, I don't know that there's a categorical exclusion. So I actually don't know the answer to that question. I do know that when the census case was being argued, that the focus was on the whole number of persons part, which is why I highlighted that language.
Right. And Sharon brings up a good point in the chat box that, perhaps we can look to the purpose of the census to perhaps determine who may or may not be counted. Yeah. So the purposes of taxes or the purposes of tracking and providing services, things of that nature.
Yeah, I mean, that that if you had a state that had a lot of undocumented people in it, that state would still need more in the way of resources if you were equally distributing resources than one that didn't. And those people aren't voting because they can't. So
I really want to get to Chris's question here too. Okay, so from time to time, there is a question of requiring very basic civics education in order to allow someone to register to vote. Mm-hmm. So what might be your thoughts on meeting some basic requirement of understanding in order to participate in the vote?
Well, that's a fraught question. So let me kind of approach in 3 different directions here. So to become a citizen, You have to know that. That's so to become a naturalized citizen, you have to know that. And they need to become a naturalized citizen, you need to know a lot more than the average American citizen knows about how our government is constituted. So I think there's a baseline there where you can say, if you need this to be a naturalized citizen, you should also need this as a citizen to be a voter. I think you could make that argument. Where it becomes a fraught question is that type of test was used in a very discriminatory way, particularly in the South, particularly against African Americans for a really long time. And so the idea that you would be able to have a test like that and then it would be fairly applied across people, there's a lot of reasons why people would be suspicious about that. Could you do it? I mean, maybe, but I mean, I think you'd have to overcome a lot of trust for that to happen, distrust rather. And then sort of the third question is, well, if you were going to do it, and if it wasn't going to be the citizenship test per se, what would it be? What basic level of knowledge would you want people to have? And, that could be, I mean, you could spend years arguing about something like that. I mean, I know one of the things that frustrates me is that I don't think I love talking. Chris knows this because I told him I like doing civics education for adults. I have nothing against children. I just like doing civics education for adults. And one of the things that I find when I do it is that even well-educated adults there's a lot that they don't know about the judiciary. And they're very interested in learning about the judiciary. And I wish that people knew a lot more about the judiciary than they do. So that might be my particular interest. That would be my particular thumb on the scale in terms of what ought to be included in civics education. Somebody else might care about other things. I mean, they might care more about, you should understand how legislatures work, or, you should understand, what the powers of the president are, it's just so hard to figure out what that curriculum should look like. And then how do you administer it in a way that's fair? But all that said, I think to not even try is a mistake. So, it's a fraught question, but I think there really ought to be a basic level of civics competence. And it's why I'm here tonight. I mean, I just think it's something that it would be good for our country for people to have.
All right. So another question, and this is specific to state citizenship. So were there any challenges to state citizenship laws before the Civil War?
Well, there was a whole bunch of early cases that the Supreme Court had to decide having to do with the rights of citizens of one state vis-a-vis other states. And actually, that's part of where the narrow interpretation of privileges and immunities came from, because there was a body of law. And so I'm not just blindly dumping on the court in the Slaughterhouse. I mean, I think those cases were wrong, and I think they were very consequentially wrong. But there was a body of precedent that they drew upon, and it had to do with, could South Carolina stop a citizen of Virginia from doing X? And there was a lot of litigation about that early on, and the court pretty consistently said, no, the states can't discriminate against citizens of other states. I think the idea was states can have their own laws, but they can't apply them in ways that discriminate against people who aren't citizens of the state.
Excellent. Okay, so for the time being, we have addressed all the questions in the chat box, but I wanted to, give you a chance to say any closing remarks before I think I'm going to give Christopher the final word.
Yeah, well, I mean, I don't have a lot more to say. I love these kinds of conversations. It's been really, really fun doing it. I love the questions. And I think you can tell that, what I want more than anything, having been a judge for as long as I was, is for people to understand what the role of the third branch is, to understand what the role of the judiciary was and is and will be. I think it's one of our treasures, actually. I think that you can always point to a bad decision. You can always point to a judge you don't like. You can always point to various things. But, I think our judiciary is one of our great strengths as a society. It's independent for the most part. And by that, I simply mean that it decides cases based on what the judges believe the law requires, rather than a leader telling them what to do. I'm doing a program next week for some judges in Eastern Europe, and in several of those countries, they do not have judicial independence. I mean, if they rule against the government, they get fired or they get demoted. And that's not the case here. And I think we take that for granted, because we can be unhappy with one decision or another, but we don't realize that actually our judges have a great deal of independence of judgment, notwithstanding what the government wants or what the community wants. And I don't mean by that they're not accountable, but you have a whole history of people, particularly in the South during the civil rights era, judges standing up to the local population. One very sort of dramatic illustration of that was in the movie Selma, where you had Judge Frank Johnson saying, they get to march from Selma to Montgomery, even though the state government was trying to stop them from doing it. This is a white federal judge in Alabama, who, by the way, ended up getting socially ostracized for making that decision, and others. But I think the judicial independence that we have is something worth admiring and treasuring. And I think, at least on the federal level, I think the states are a little bit more of a checkerboard, but on the federal level, we have a really fine group of people, which is not to say that there aren't people who are better at it than others are, but I mean, it's a quality group in terms of their intellect and their dedication to the work that they do. So I'm proud of that, and I want to be able to put that out. And at the same time, I think we should always try to do better, and we should always try to have a more just society. But I think that's part of the thing I really like about doing programs like this.
Well, and it's amazing, Judge, because in so many ways, I couldn't agree more. I mean, there's something so special about the third branch of government. There's something very special. It's also the branch of government that is hardest at certain times for the public to access, right? And it's only because usually most people are not in a federal court, and if they are in a federal court, as you said before, it's because of an issue. It's not necessarily because they're just visiting, and I wish more people would take advantage of the chance to just even see what it's like in a courthouse. And what it makes me think, Judge, especially considering what you just said, and I'm so curious to hear your thoughts on this. You sat on the bench for so many years. You've trained literally hundreds and hundreds of other federal judges on how to do the job. What's something that sticks out in your mind as a judge, and you are trying to grapple with difficult constitutional questions, often in conflict, and thinking through, and you even mentioned legal realism before, so that's my professor hat coming out a little bit. What are some of the things that you think through or go through, or that people might be interested in from the public's perspective?
Well, so I'll try to give a short answer. So there's 3 cardinal virtues. It's nice to have a 3, it's not 15. There's 3 cardinal virtues. One of them is an evidence-based process, and I think you don't need to look any farther than the election cases, the ones that we just had. What you really saw in those cases was that the judges were evidence-based. They made decisions based on the evidence, not on political views. And whether you like it or not, I mean, I think they did. I mean, it's very clear. So evidence-based is a key part of this. Procedural due process is a key part of it. That is that everybody has a right to be heard, and you want to make sure that that's real. It isn't just going through motions. You really want to give people an opportunity to be heard. And then the third is the rule of law. It's following the law. You have an ethical responsibility as a judge. You take an oath to follow the law, which means you can't disregard the law. You have to look at what the law is, and you say, okay, well, here's the evidence or the lack of evidence. Everybody's had an opportunity to state their claim. What does the law say in this situation? And of course, people are not always going to reach the same outcome, but that process is common to all judges. So I think that's the core of the judicial culture. And then I think the next layer on top of that is trying to explain it to the public. And this is something where I think the judiciary has not done particularly well and needs to do better, is why I think civics education is important. I mean, I think sometimes you get caught up too much in the technical language and not enough in trying to explain to people what the case is about and why you're reaching the conclusion that you are. It's like going to the doctor. I think this is a good analogy. If you go to the doctor and the doctor, throws a bunch of Latin at you, and you have no sense of human contact, you're probably not going to feel very good about that, right? I mean, you hope that the Latin's the right Latin for whatever it is that's ailing you, but in it's the same thing in court. I mean, if the judge is kind of stoic and dispassionate and no feelings or anything like that, you don't really get the sense that the person is thinking about, well, what's the human problem here? Why is this case here? Why do these people care? And I think that's an area that when I was at the FJC, we really tried hard to get judges to cultivate, was these people skills. How do you communicate? How do you listen? How do you develop emotional intelligence? How do you stay present when somebody is being emotional in your courtroom? I mean, that's all kind of subtler stuff than knowing what the law is and being able to write an opinion. But I think it's really important, because then when people who are not lawyers and judges go to court, they want to be treated well. They want to be heard. They want to be respected. And I think there's a skill set that judges can develop, which makes it more possible for them to convey that. So I think we have good core principles. I think this sort of behavioral stuff is where there's work to do.
Well, and it's funny, Judge, because on that, laughing, you're making me laugh, because the first, and I know you'll remember this from your law clerks, the first time I drafted an opinion from my first judge, he handed it back to me and he said, what is all this gobbledygook? I know they taught you this in law school. The point is to communicate what we're doing. And I remember that very succinctly, thinking about how, yeah, that's right. It's not law school anymore. My job is to help you communicate your decision. It's a very different idea.
It is. And, clients, the people that the law schools train lawyers to go out and do stuff. And then the lawyers get out there and they're actually representing real people.
Yeah.
And the real people say, what are you talking about? I mean, I don't care about that. I mean, I care about, what are you going to do for me? Or, how are you going to get this person to stop, get their dog to stop barking, or whatever the problem is, so I think that's an area where the legal profession and the judiciary have work to do. And I think
Judge, I want to pay you this lovely compliment from PJ, who says your enthusiasm is truly refreshing. And PJ would enjoy a series of you discussing the Constitution today in light of its original construction.
I've got to say, and it's a great note to end on. I mean, I love doing these programs. I really enjoyed this one, and I think this whole series is a great idea. Because it's trying to get, we've got all this great stuff to work with, but we have to understand it. We got to really understand. We can't just kind of float around and, oh yeah, it's Constitution, Madison, whatever. I mean, it's like there's really some stuff here. So.
Thank you, Judge. We have so appreciated this evening and have certainly appreciated your time. And I just want to remind everybody, You will get a link to the recording of tonight's session, so you're welcome to watch it and also share it. You are absolutely welcome to share this with students, with friends, with whoever else you think would enjoy it. This is information we would just love to get out in the world. And I'm going to let Christopher cue up next week's presentation.
Thank you so much, Emily. And Judge, thank you so much for being here this evening. This is so, so wonderful. And you know I'm going to have you back for things. So
I'll look for your email, Chris.
I know. I'm really excited. Actually, we just found out today that next week, we're going to have a U.S. attorney from the Northern District of New York joining us. She is the U.S. attorney for the Northern District to talk about the Fourth and Fifth Amendment. And I just found out today that we are actually going to have her as well as the U.S. attorney for the Southern District of Florida, which is Miami. And they've been friends for a very long time. They're long-term employees of the Department of Justice. And they're going to be joining us to have a conversation that I'm going to help moderate about the Fourth Amendment, the Fifth Amendment, and the reality of what it's like to look at policing and prosecution in America and some of the history of that, community relationships, and how that looks, especially when it comes to being a prosecutor of color. So I'm really looking forward to that conversation. I really hope that everybody can join us for that. I think it's actually going to be one of the highlights of this incredible series.
All right. Thanks a lot, everybody. And we look forward to seeing you next week. Bye.
Thanks all.